Good evening, chat. Hope you guys are doing well. Hope everybody's there. Clyde Coin is up today. It's up every day, chat. Talk about 10x results, 1000x results for Clyde Coin. It is never bad. It's never down. It's always up. I mean, think about it. Hey, Clyde. Come here, bud. Come here, Clyde. Over here, Dingleberry. Come here. Come here, Clyde. Hey. Clyde. Come here. Come here. Buddy. Come here. Come here. I mean, look at this guy. Always up. Always up. Always going up, chat. Always going up. Always going up. Yeah, make me work for it. Jeez. It's always going up, chat. It's always going up. Clyde Coin, look at this thing. Look at this doggo. Look at him. Look at him. Would you ever say he's down? He's always up. He is always up. Mwah. Always up. Always up. He's always up to the moon. Yeah, good boy. Always up. Look at him. Look at that regal look. All right, chat. All right, buddy. Uh-oh. What are you caught on? There we go. That would have been bad. All right, Clyde. Here you go, Bubba. Good boy. All right. No. That's it, buddy. No. That's it. Clyde looks thin. Call CPS. No. Bye, Clyde. I miss Clyde already. No, that's okay. He misses you too. Just saying though, Clyde is never down. He's never out. Keep that in mind. Anyways, guys, I hope you're having a great Friday. It is Friday. Byron Tomsky says he pimps himself just for us. Yes, he does. Yes. Yeah, he's looking for a peen. He's got a peen he's chewing on. Jello says, I see what Dick said. I don't really care what he has to say. So, no. I'm sure it was something about being fat or whatever. Who knows? James says, he watched the video of Monty introducing himself to me. Yes, when I actually got to meet Montegraph when he came on my channel. That was hilarious. It was a very interesting night. Annie Land says, I spent over $800 a month on dog food now. That's are you feeding them people? Are you you can kill hobos and feed them to your dogs, it'll be cheaper. Oh. That's funny though. That's a lot, but I could be really, I mean, I'm not saying it's bad. I'm betting it's really good dog food, but holy cow. That's what is it? Yeah, I mean, do you have like a herd of mastiffs, or I'm hoping you're not telling me it's for like a toy poodle or something, because then you really have some explaining to do. All right, guys, but yes, it is Friday. It's been fun. It's been a week. I mean, it was Labor Day. I mean, holy cow, it's the weekend again already. We're going to be getting into the heart of September here pretty quick. So we've got a couple things to talk about. Like I said tonight, Kari Morrissey can't stop coping. And I think it's funny. She just won't let the case go. And I think Judge Marlowe has finally gotten to the point where she's like, no, Kari, we're done. And we're going to see that. Sleazy says someone's worked Labor Day. Oh. I need to get sponsored by Chewy. I do, but I don't think I warrant their attention yet, but maybe at some point that'd be worth it. It's that ready-made by Ross. Okay, I can see that costing some money. Yeah. Whiskey Chick says Costco food is great and inexpensive. And Jess Joy says, thanks for the hemp treat recommendations. It helped your dog on the car ride today. Oh, well, that's good to know. That's good to know. All right. All right, everybody. We got a couple minutes in here. It's time to get going. And yes, if you were wondering, yes, the Alec Baldwin case, I mean, it's over. It's over. It's been done. We're over 45 days now past. 45 days past due, chat. It's been done. It's been dead. Except for Kari Morrissey. She just won't let it go. And she just won't let it go. So what did she start off with? So she started off with this. So Kari Morrison filed a motion for the extension of page limits to the state's motion to reconsider dismissal with prejudice. Remember, Kari Morrissey, in the middle of the trial, we had the issue with the extra rounds that Troy Teske had. And they were taken to the police station in the middle of trial. And all that happened. And then the judge ended up dismissing with prejudice. But remember, it wasn't just that. Yes, that was a massive Brady issue. Potentially exculpatory evidence was withheld. Yes, she's the one who fucked up the evidence sharing. Yes, she was the head prosecutor. She's the one who kept on taking her glasses and going like this and going like this, like every 2 seconds. So it wasn't just that. Remember, guys, as the judge said, routinely in this trial, especially the Alec Baldwin phase, which we later found out applies to Hannah Reid, there are routine issues of them fucking up discovery and withholding discovery, and they kept on going like, oh, sorry, I'm a big idiot later. Well, finally the judge said, no, you're done. You've screwed up too many times. It's over. And she dismissed the charges with prejudice, meaning they're dead, they're gone, they're never coming back. Bye-bye, it's over. So what did we get? Well, Kari won't let it go. So she filed this. And this is something typically you have to do. You have to, if you're seeking, and you are limited at times. Under local rules, your motions cannot exceed 10 pages. Okay. Well, if your rules say you can't exceed 10 pages and your motion's greater than 10 pages, you have to do something. You need permission from your court to allow it. Now, in this case, she filed for an extension of page limits. Okay. Or you might see people filing a leave of court to file you file for leave of court, meaning the court's permission to submit an extended or oversized or over limits brief. And that happens. So she filed it, and she filed it August 30th. And then she says that here comes the state of New Mexico. And she said the defendant was granted leave of the court to file her motion for a new trial in excess of page limits, and the state requests the same for its response. Okay. The motion is currently 34, and it's actually 54 pages long with header conclusion and certificate of service, not excluding exhibits. Now, typically, with header conclusion and certificate of service, a lot of places don't count that because that's not fair, because sometimes your certificate of service is an extra page where you say, like, I hereby certify that this was served upon the defendant or the prosecutor via facsimile or hand delivery on such and such date. We tend to not let people do that because that's not fair to them. They said attorneys for defendant were contacted via email, but as of the filing, have not responded. I'm sure Alex Spiro is already on to bigger and better things, doesn't actually care about what's going on. He's just, screw this, we're out. F this, I've got bigger problems to worry about. So she says, wherefore she requests the court to enter an order allowing extension of page limits. Signed by Kari Morrissey. And she says, I hereby certify the pleading was filed through Odyssey system, and it allows everybody to be served electronically. So she says, I did it today, and it's done. Now, what did she file? Well, here's what she filed. And here's the thing. Oh. She files a motion to reconsider the dismissal with prejudice. Now, if you notice, There's a couple things. One is the page size of this document. It's big. It's huge. It's huge. I mean, look at this. 52 pages. Like, look at that up there, chat. 52 pages. 52. 52 pages. All right. Well, when did she file it? That becomes the next issue. She filed it on 8/30/2024 at 8:05 p.m. So a couple hours later, she files this. Now, notice what I haven't shown you is an approval. So she files this 52-page motion. And it's a motion to reconsider the dismissal with prejudice. In support thereof, the state submits the following. Now, here's the thing. Because the judge dismissed it with prejudice and it wasn't an acquittal by a jury, Kari Morrissey can appeal this and file motions. If this was a not guilty from the court, or if there's a not guilty verdict, it'd be done and over with. But because this was a dismissal, there's a different issue here. Raptor, I'm going to be covering this probably. I'm thinking about covering this tomorrow, the actual copyright lawsuit. Don't worry, we're going to get to that. I think it's interesting. It's kind of funny to look at. But yes, Fudbusters, friend of the show, Matthew LaRosiere, owner of MAF-arms.com. If you'd like to buy your wind chimes there, MAF-arms.com. Use the promo code POTCRIM. You can get a couple % off. I think it's 10% off. Promo code POTCRIM. I can't show the ad, I think, because that counts as an advertisement for a no company. But even though all they do is sell wind chimes, I'm not sure what the big deal is. So she's filing this motion to state the fault, and she wants, and she basically, and this is cope. This is all cope. But she says, no, judge, they're facts you didn't understand. There's part of the story you didn't know. There is no violation of Alec Baldwin's due process rights. Alec Baldwin was aware of the existence of the ammunition and the characteristics of it prior to trial. And it's not favorable to him in his defense. No, judge, you don't get it. No, stalker child, is the judge saying. Kari screams, no, judge, you don't understand. You don't get it. You just don't get it, judge. Now, this is an interesting part of this. We're not gonna go through all 52 pages. There's a reason why in a minute. This is an interesting part here. The gall of this woman to do this. The state requests the court order defense counsel to provide a description in all documents related to when and how they learned of the Troy Teskey ammunition, so the court may properly consider the prejudice to the defendant and a record for possible review by a higher appellate court. Now listen to that. Listen to that. She wants that. She wants Alec Baldwin and his attorney to disclose all kinds of things about what they may have known as an excuse for Kari Morrissey to say, well, I don't have to show you. It's okay that I didn't show you because you knew. This is that is impressive. That is impressive. That was the one thing when I read this, I'm like, you've got to be shitting me. You've got to be shitting me. You know, she wants defense counsel to disclose all their documents to when and how they learned of this. I mean, how are they going to know? Even if they knew, Kari, you still have a duty under Brady v. Maryland to disclose the information. You still have a duty to disclose it. Jason's saying, isn't that work client product? Is it not protected? Well, work client or work product would be if Alex Spiro was taking notes. That's work product. Or if he's working on something. Now, if he got a hold of a document somehow, there might not be work product necessarily. But yes, if I'm Alec Baldwin's attorney, it's all work product. It's all things I worked on. It's all things I generated or used in the benefit and the representation of my client. Yes, there's attorney-client confidentiality. And remember, as we learned in the other cases here, attorney-client confidentiality extends beyond you and your client, but to other people involved. So, like Brian Steele, when Brian Steele is being held in contempt by Judge Glanville during the Young Thug trial, attorney-client confidentiality extends to things you're doing on behalf of your client. Like the judge said, you have to tell me. And he said, I can't tell you because the rules of confidentiality prohibit me from telling you. So, yes, there are a lot of ethical considerations there. And she's demanding they show it. I mean, that already there's a bunch of problems. But yes, at the end of the day, Alec Baldwin's attorney is going to say, no way in hell are we doing this. Absolutely not. And just the gall of this woman to put that in writing. Yes, the judge should order the defense to explain how they knew we withheld exculpatory evidence. Yes, go fuck yourself is the right answer. Yeah, Jason, no, I think that was 100% a great answer. I think it was a great answer, a great question. And Lego Life Law and Libations, hello. But yes, that's a shame. You're correct. Yes, explain to us how we knew. No, we're not doing that. And then, yes, Carrie's coping and sneezing. Yes. Now, how's the rest of this work? This is 50 page. Like, look, she just keeps throwing everything back in here. All the pictures from before, yada, 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 yada. I mean, she's like, look, there's dummy rounds visible in this run. Judge, you don't get it. No, Judge, no. And she just goes on and on and on and on for page after page. I mean, most of these pages are because of the pictures she took and shoved in here. There's all kinds of garbage in here. This is just on and 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 on. They finally just getting to here. She says, like, the state agrees the Teskey supplemental report describing the rounds were not provided to the defendant. Okay, well, that's important. And while she was not in possession of the supplemental report, was unaware that lapel video existed, she agrees the knowledge possessed by members of law enforcement is room to be known to the prosecution. Yep. Yes, and that's a thing. When you are a prosecutor, what the police have is imputed onto you because you're on the same team. They do disagree, though, that Corporal Hancock should have interviewed Troy Teskey before unilaterally deciding the ammunition turned over was relevant and should be. Now, she likes to say commingled. That's her way of just trying to act like it's not important. It's like, no, she should have interviewed, and they didn't do anything. But that's the problem here. There's all kinds of issues here about what happened, and she just won't accept them. Oh, Laney's barking. So she just won't let it go. And yes, once again, she says they request the court order defense counsel to provide a description and all documents related to how and when they learned Troy Teskey's ammo, so the court may properly consider the prejudice. And she says, please reconsider the language in the order granting Alec Baldwin's motion for dismissal and sanctions under Brady and Giglio concerning the veracity of Marissa Popel. And remember, she's the CSI tech who was screwing around with the ammunition when it was brought in and was acting like all laughy and having a joke and a smoke. Yes, the smart prosecutor walked away. Tim the Tool says, please go through it page by page. Well, we don't have to. Because we also have to go through 110 pages of exhibits. Exhibits 1 through 4 she submitted. So it's 52 pages plus 110. And these are transcripts. A lot of this is transcripts that were provided and used. I mean, look, there's transcripts that are included in here. All kinds of great stuff. Okay. Well, what's the next thing Kari Morrissey submitted? She then submitted 279 pages of exhibits. This is it gets better and better and better with this woman. I mean, so here are the other exhibits she submitted. And this is all the garbage from the movie set. I mean, she goes through everything. We're only 100 now. It's 190 pages in, chat. Here's another bit of the transcripts, all kinds of stuff she submitted. She basically resubmitted everything, and this is very obnoxious. And what do we get with all this? Well, the court this week and yesterday. Funny you should ask Tim. Should we go through all of this? Hold on here. Where is? Yeah, she basically resubmitted the whole case. If he was the real PPP lawyer skin, I would ask for subs to read all of it. No, God, no. There's an easier way to do this. There's a, chat instead, we'll show. There's a felting. That's even better. We don't need to read all of it. Because Judge Summer yesterday filed something that takes care of it. She just nope, not doing it. Not doing it. We're not doing this. And she says, order denying the state's motion for extension of page limits to the motion to reconsider dismissal with prejudice. And she says, this matter came before the court because the state filed for an extension of page limits. Okay. Having reviewed the briefing and being otherwise fully advised, the court finds and concludes, the court rules on the pleading filed without hearing. And she can do that. She doesn't have to hearing. She can read it and go look at it and yeah, I ain't doing this. And on August 30th, 2024, the state filed a 52-page motion. The state additionally filed 387 pages of exhibits. The state did not obtain advance leave of court to file its motion well in excess of page limits. Now, here's the point. When you file page limits or you file an extension, you can file it like Kari did, which is called instanter, meaning right then and there. But here's the thing. Kari knew well in advance she was going to be way over. She should have done this in advance. You don't just do this. You don't just do this. That's not the proper way. You can get away with it, but when you know already you're going to be just dumping a massive set of pages on there, you need to do it in advance. You know you're going to need it. Do it ahead of time. It's a far more intelligent way of handling it. It's just there. Like I said, guys, there are ways to do things, and there are ways not to do things. So it all depends. It all depends what you want to do. But you can, for example, here, chat, we're going to use this. This is a great example of it. This isn't Hannah Reed's case. And as much as I don't like Jason Bowles, and I think he did a lot of things bad, he does a lot of things right. And what did he do here? Well, he showed up, and on the 16th, he filed this motion for extension of page limits. Okay, so he comes in, and he says, following the trial, he said, under local rule, I can't exceed 10 pages. Currently, I'm at 23 pages long with header, conclusion, and certificate. And he said, Kari Morrissey takes no position. All right. So he asked for permission to enter an order allowing him to see the page limit. Okay, cool. And guess what happened? Later that day, we got an order to exceed the page limit. Now, this is also, you could make arguments about what kind of case this is or anything like that, sure. But look, because you filed it, they may exceed the page limit to file. Cool. And then we'll go to this. This is the timeline here, chat. So here is the Motion to exceed page limits. Down here, you have the motion to exceed page limits. You have the motion for page limits. And then you have this. And then you have other things that they filed here. You have the state's response. They did it the right way. They did it the right way. So there are ways you can do it. There are ways you can do it. There's smart ways to do it. But yes, Judge, but we're going to get back to what Judge, to the great jurist, Mary Marlowe Somer did here. So she said, if you don't obtain leave, you require an entry of when you file a brief in excess of 10 pages. And this is the local rule. It doesn't include the cover page, conclusion, certificate of service, and exhibits without an order of the court. So you're allowed to have parts of your brief that don't count. But this was obnoxious what she did. So what does she do then? And now here's the important part of this. Compared to Hannah Reid, given the procedural posture of the case, and this is why. This is one of the big reasons why, too. Not only was the size, but the posture of the case. Procedural posture. What stage of the case are we in? What position? The posture of the case. It's already been dismissed with prejudice. It's done. The court must enforce a local rule to regulate the court's docket and promote judicial efficiency. Now, there are times where if you violate the local rules, you could sit there and make a claim like, but Your Honor, the interest of justice. I've done that before when I've screwed up on local rules. It's a very common thing. Like, look, Judge, the interest of justice. We're trying to deal the case, Judge. Please work with us. Okay, cool. The case is done. This one's done. Nothing left to do. And they point out that the court's inherent authority extends to all conduct before that court and encompasses orders intended and reasonably designed to regulate the court's docket, promote efficiency, and deter frivolous filings. And they point out that counsel is cautioned to comply in the future with the rules of appellate procedure. Yes. And sanctions may be appropriate for violations, but more importantly, they say, in our experience, briefs that exceed page limits, even when this court has approved them, are almost invariably unpersuasive. A winning argument can fit within the limitations of the rule. And this is where they're pointing out less is more. Less is more. This is their way of saying that. Less is more. This is what matters. This is the critical thing here. And this is very true. If you can't say it within 10 pages, you might have a problem. But there are times where it's different. On an appeal, you're going to have a lot of pages. But this is different. So the court finds the state's motion for extension of page limits is not well taken and should be denied. It is therefore the state's motion for extension of page limits with prejudice is hereby denied. Okay, so what does that mean? Well, they say sent to Kari Morrissey, goes to Luke Nikes, Alex Spiro. I don't remember Michael Nosenchuk, but okay. I do remember Sarah Clark. And then Heather LeBlanc was involved. We remember her. So what does this do? Well, it's over. It's over. Said I always go over page limits. Hello, David. Oh. Yes, but it's done. It's not coming in. She's not accepting it. You filed an improper filing. The court is not accepting it. It's denying it without a ruling. It just says, I'm not listening to this garbage. It's denied. You're done. And your motion for all this garbage, I'm not looking at. So, yes, she got felted. Yes, this is a monster kill. Kari's done. You go one page over to see if people read it. That's never a dangerous thing there. Dolly says, so Kari can't redo it. I mean, that's the issue. Like, you could. But I think the judge is already pointing out the way she said it. When she focused on the procedural posture, this is her way, I think, of trying to telegraph to Kari, I don't care. You know, the issue of procedural posture here, I think this is given the procedural posture of the case, I think she's very much trying to say, I don't give a fuck and you're wasting my time. To me, that's what those sentences say. I think she's done. I don't fucking care. Fucking knock it off. You're wasting my time. Leave me alone. Fix it. Does she have time? I mean, I don't know if she has time anymore. But yes, I think the judge is sending a signal. Leave me alone. You're done. You lost. Take your L, Kari. She wants to go to the Court of Appeals anyway. I don't know if she's filed an appeal yet, so she'd better hurry the hell up. I don't know how much time she has, but I can't imagine too much. Luke says, there's so much cope Easter eggs in that motion, it's worth going through. And I understand that, but remember, at the end of the day, this motion, here's the point. It doesn't matter. This is all for naught. We could read the motion, but it's literally a dead man on arrival. And I don't like doing that to you guys. Because if we know it's dead and it doesn't matter, I think you should know that. You should have a right to know that. We can watch it and we can, and honestly, I started reading it and I saw the court said it's dead. I stopped reading because I have other things I can do. I have other things I can work on and spend my time on. So I quit reading there. But we can work on that. We can work on looking at it. Haley says, I could just imagine Kari chucking everything off her desk. Yes. Oh, you just want to go to page 36. Okay, let's see this here. All right. Page 36. Oh, okay. Yes, I did see this clip on I did see this part on Twitter. This is pathetic. Yes. It is worth noting the defendant was being supervised, it was being represented by at least 9 attorneys. Oh no. Oh no. Oh no. He has too many people. Yes, you finally found somebody. Yes, for one of the few times in history, the defendant has a bigger checkbook than the state does. Yes. Oh well. Oh well. Oh no. Oh no. You can beat me to death with money. Yes. That's what Alec Baldwin did here. This is literally, I don't know about Heather Blanc, but like most of these guys here, most of this team here formed a fucking murderer's row. I mean, Alex Spiro and Luke Nikes came in there just swinging their dicks. And Kari didn't know what to do. And she said all of them were present in New Mexico for the trial. Although she messed up here because she already has a parenthesis right here. And then she starts another parenthesis. She should have a second parenthesis right there. But she didn't do that. And the state was represented by 2 attorneys who did not have the human resources to respond to a motion to dismiss and prepare for the next day's witnesses in one evening. Womp, 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 womp. The fact the motion was raised during trial was a tactical decision. Okay, that's how it works. By defense to take advantage of the limited resources. Okay, so what? So what? So what? It was a tactical decision. So what? So what? They're allowed to do that. There are tactical decisions. This shit is chess sometimes, Kari. Thomas said, should have a triple parenthetical. Well, if it's only 2, a parenthesis inside a parenthesis, I think it's just there. But yeah, this is sad. This is sad. She's just so sad. Can I complain the state has more attorneys than I do on future tickets? I'm sure she'll complain and say, well, that's just how it is. Yes, and she keeps on crying about the fact they're big city lawyers from New York City. New York City! Yes. I'm surprised she didn't bring up, Your Honor, did it ever occur to you they might Your Honor, did it ever occur to you these guys might be Jews? Your Honor, are you going to let these Jews come into our New Mexico courtroom and big league us? That's what I'm waiting for her to say. Are you going to let these little round hats come in and bully you in our great cowboy state? The poor state can't handle stress. I hear there's something out there that helps with the stress, and then if you take it, your stress levels go from here to up here. She should look into that next time. And that's a shame. Brings up a great point. Why the fuck weren't you already prepared for that witness? It was your witness, bitch. And I agree. When I've had trials, when I was a prosecutor, and I had all the witnesses I'd bring in or out, you prepared them in advance. Now, somebody like a critical witness, you might just like recheck the afternoon of after a trial. But generally speaking, you got prepared because, you're exhausted. You have very little time to prepare anything else, and you got to sleep and do everything else. I also have work I had to take care of during the day. Like other things, I still have to take care of my job. So no, I'm not going to waste time re-interviewing a witness. That should have been done well in advance. You prepped them, they're ready to go. You should basically, I got my file, that part of the file for that witness, bring it up, open it up, and start going. Yeah, this is absolutely garbage. Yes, the paragraph justification is off. Yes, very sloppy. Now, she says the defense knew that some of the rounds turned in by Teskey were the same or similar to the live rounds from the set of Rust, and they laid in wait to move to dismiss during trial when it had a tactical advantage. Yeah, that's how this works. That's how this works. I will hold off on something. It's no different than if the state forgets to prove venue. Remember, part of it is, when you hear them say, did this occur in like Santa Fe County in the state of New Mexico? That's them establishing the venue for the court case. That's one of the elements of a crime is that it happened in that jurisdiction. Otherwise, the court can't hear it. And I'm going to sit there. I've had cases like that where the prosecutor forgets to do it and you get all the way through and you're like, Your Honor, and as soon as they rest, you say, Your Honor, I want to dismiss. They haven't just shown venue. Now, sometimes there's courts like, oh, I'm pretty sure they did, and they overrule you, and you're like, oh, this is bullshit. But once in a while, courts are like, yeah, I don't think they did. Case dismissed. Didn't prove it happened here. Sorry. I'm not going to sit there and go, hey, Mr. Prosecutor, I think you forgot something. No. I'm going to tuck that in. I'm going to take that, put it in my pocket, and be like, we're going to hold on to that for later. It's a secret tool that'll help us later. That's how it works. You hold on to those things. There's nothing wrong with a tactical advantage. The defense scheduled its third evidence viewing for this case in June, and that the defense suddenly canceled it without explanation on June 17th after CST Popple had prepared hundreds of items for viewing. So the fuck what? Something happened. They couldn't make it. Oh well. On July 12th, undersigned counsel expressed herself in court that the defense was aware of the Teskey rounds before the trial and likely learned of it from Ms. Gutierrez's counsel. Perhaps this was the reason they canceled their viewing. Okay, oh well. Oh well. Oh well, Kari. Oh well. It doesn't matter. You knew about it. You had it. You didn't turn it over. Because like you said, I decided it wasn't relevant. That's the problem. You made a decision. What you did is the problem. Not what Alec Baldwin's attorneys did. It's what you did is the problem. Defense counsel responded he shouldn't have to disclose this information to the court, and if he had to, it should be provided in camera. This is all just fucking garbage. They're saying, oh, well, the court agreed to address this issue, but it never did. Well, it doesn't have to. It doesn't fucking have to. It's over, Kari. It's over. It's over. You committed Brady violations. You're done. Oh, MLS. You're like popping in on other things. I'm still God. How are you doing, David? If you want, I can send you. If you're interested, I can send you a link. But I know you're probably out and about. So, bearing your opponent at work is the SOP in many cases. Yeah, if you could do it, do it. This is a standard civil practice tactic. But in reality, here's the problem. Those attorneys realized, like, oh my God, they fucked up, but they actually did it. We're going to spring the trap. They put a motion together. That's the advantage of having a bigger thing. Yeah, she ruined her reputation over this. Imagine that you ruined your fucking reputation over some dumb Ukrainian chick getting shot on a movie set. That's imagine going to all this. Yeah. This is just sad. It's sad and pathetic. Sad and pathetic. So that's the ballad of Kari Morrissey right there, chat. Just it's not very impressive. The Amateur Iconoclast gifted 1 membership. Thank you for the support and the thank you for your support and your generosity. Pirate Tomsky for £2 sterling. The King Sterling. Now, if you live in a place or you don't feel that affinity for the monarch, let me know and I won't refer to it as the King Sterling next time. It says Kari Morrissey, the ultimate Yes, it very much is. Cyberpunk says, to be fair, I still don't see how the materiality was met. Concede a Russian bad actor planted a live ammo on set. Does that erase the fact Baldwin pointed and pulled the trigger of a gun? It does, in the idea that if there was sabotage, he had every right and belief that he could do all these things. And that, yes, if there's sabotage, there are intervening events. Like, if there's an intentional act to cause problems, I would argue that changes the entire analysis here. So let's say it turns out that really all happened. They wouldn't have charged Baldwin. I guarantee you they wouldn't have. But remember, at the end of the day, it's not Kari Morrissey's job to say you don't get that evidence. I don't think it's important. Give it to the defense and let them decide what's important or not important. Jay Wolfenstein for $2 says, less cope, more Sneed, please. Well, you're going to get a little bit of everything. Jason Lazat for $5. Thank you, by the way. I was saying, how pissed do you think the judge is? Can the judge hit her with disciplinary action to spank Kari back into place and stop her? Well, she's allowed to file motions. She's allowed to file a motion. And that's not the issue here. The judge is just trying to be nice, saying, like, Kari, I don't give a fuck. Now, if she keeps doing it, the judge could probably, like, warn her that I will file sanctions against you or I will grieve you. But for right now, she has not broken the rules of professional conduct. So that's not an issue for Kari. She's being good overall. It's just like, come on, you can't fucking do this. Momosaurus Rex says, could Baldwin's lawyers still file a response? Or is Judge Summers shut that down too? They could if they wanted to, but at this point, the court has denied it. The court denied her motion without hearing and just like, nope, I'm done. I don't even think she read it. At that point, no, you don't. I mean, you could file a motion, but if I'm Alex Spiro, the case is done. It's gone. He's already moved on to other things. So, number one, you're taking care of that. Number two, Alec Baldwin's paid you, sure, and you're billing him. Part of your duty is to limit the amount of billing for your client if you can. The court's already ruled and denied the motion. You don't have to respond. And I would argue ethically he has a duty to maintain efficiency in his representation. And then number three, the bigger thing here is Judge Selmer is on your side right now. She's very mad at Kari Morrissey. She doesn't want to hear it. If the judge doesn't want to hear it, she probably doesn't want to hear from you. So this is one of those times where you just keep your mouth shut and sit in the corner and let Kari get her ass kicked. Because if you just sit there and like go back to doing your own work, nobody's going to care. So just flying under the radar is the best. That would be my strategy if I were them. And I'd say it's for all those reasons. I've got other things to do. I need to, shepherd how I bill Alec Baldwin, because that could easily be another $5,000, $6,000, $10,000 for that motion if they responded to it. And then three, I don't want the judge pissed off at me. So we're just going to be done. Don't interrupt your enemy when they're making a mistake. And I think that's very true here. Kari Morrissey's making a mistake. Let her cook. Let her cook by herself. AI Designs sends in £4.99 for a super sticker. Well, thank you. I appreciate that. Pirate Tomsky for £5 sterling. Again, the King, Sterling, is saying, Your Honor, they had them fancy New York City lawyers. So decided to hold back evidence in case they did some weird magic and won the case. Yes, Kari, probably. Yes. Yes. Yes, she was worried that, Your Honor, they might do some of that Jew magic. Kari embarrassed herself on the world stage. Yep. Yes, she did. So it's just there's no yeah. And then Cedar Rose gifted 1 membership. Thank you, Cedar. Thank you for your support and your generosity, helping to keep this chat gray free. Thank you very much. Yes, use gypsy tears to counter the magic. Oh no. It's going to be even funnier when Hannah gets a new trial. I think it's going to be even funnier if Hannah gets her charges tossed. Like, that's really the problem there. She might just get her charges dismissed. Because remember, all these Brady violations occurred in Hannah's case too. So, sorry, my neighbor's car is going off. Seriously, bro, come on. Oh, whatever. So, what would you do if you were in Kari's shoes? Apologize and shut the fuck up? No, I would just. You got to move on. Take your L and move on. It's done. It's done. Maybe try the appeal, but that's it. I wouldn't have done this. I wouldn't have done all this. Yes, Your Honor, they're the Red Sea pedestrians. We can't. You have to be careful, Judge. They shapeshift. And then Pirate Tomsky for another £5. Thank you. Is saying, I saw Kari running around New Mexico wearing a Baldwin mask and brandishing a 45. Round 2 is coming soon. Yes. She's like, I'll get him this time. Yeah, she's the Mission Impossible face maker. So she put the mask on and run around the movie set. Like, Mr. Baldwin, are you here? Yes. Yes, I'm here. Boom, boom. And she just stands there, drops the gun, and walks off. Let's see here. Bumpy, I don't know what you're talking about, so. Kat, that's actually a good question. Can a lawyer not attached to Hannah's case write a motion for her case against Miss due to Brady? No. Remember, you have to be, you're entering an appearance, meaning you have to be stating I'm working for Hannah, but Hannah has to hire you. So if you try that, you're now interfering in a case where you haven't been hired by the client. That's actually a very, very big deal. You can't just show up and file motions. That will get you in deep shit very quickly. So kind of like what happened in that what's the name of that? Chad Daybell case up in Idaho, where that attorney just filed a motion out of nowhere and he wasn't involved in the case at all. That one, especially the death penalty case, that attorney got his asshole reamed out for that. He got in deep shit for that. You can't be getting involved like that if it's not your case. If it's not your case and that you haven't been approved to be on it, you can't jump into it. You have to stay out. Yes, Mission Impossible face mask and the actor is the same. Yes, I forgot he's in the Mission Impossible movies. The movie on in the background, Room 1408, is pretty damn creepy. Oh, I don't know my background. There could be an interpleader. Yeah, I don't know if you'd be able to interplead into a criminal case like that because it's. I mean, this isn't a civil thing. I don't know. I mean, you can't really interplead. Can you interplead in a? I mean, you can't do an interpleader here in Ohio for a criminal case, but can you interplead like in? I mean, it wouldn't work. I mean, you'd have to show you have some. I mean, because typically when you're doing interpleader, you're like involved in the case or you have some sort of ownership or stake in it. I don't know how you'd bring that up here. I mean, like how, like you'd have to show you have some sort of right, and I don't know what you'd be able to claim. I mean, like victims don't have the right to interplead, really. Victims can file motions, but they're stated as victims, like that are filing motions or notices. So, no, I'm trying to think. Like, could you do as an interpleader? I don't think you can. I don't know where you'd be able to do it. But maybe you can. Like I said, I don't know. I've never claimed to be the smartest guy in the world. So um Justin's bringing this up. On Nick's case, there's a taken under advisement from today. Not sure what that it's about. I don't know. Maybe his attorney did file something. Remember the whole thing with filing of the bond stuff took like a couple of days. So maybe the motion pops up later. Taken under advisement means the judge is looking at the case finally. He's taking a look at the motions and the merits. The way you do taken under, like, that's what taking under advisement means. Because he's not going to look at it ahead of time. He's going to wait till both parties submit, and then he'll read. And then he'll give it a look. Because before that, if he's viewing one side and he's had the defense motion for weeks and weeks and weeks now, that would be unfair. So he's going to take them, and now he's going to sit down. He's going to look at them and like, okay, yeah, and I'll do some read case law, open up a book, fire up LexisNexis, start reading some cases, and figure out what he's going to do. So he's taking it under advisement. So he's basically said, I'm going to start assessing who's right in this situation. So that's all it is. That's all it is. Cedar Rose says it's autumn white girl time. Oh my gosh, yes it is. The one courthouse I go to, one of the court deputies, the court security guys, he does all the decorating around the security, because there's like when you walk in, there's the security desk, and right next to it's a metal detector. It's like you have to come in through like either the two doors. You end up having to be right there, and he decorates it all the time, all the different holidays. I noticed it yesterday. It's all set up for fall. It's like harvest. He's got scarecrows out and everything, and pumpkins and gourds and stuff. And I just looked and I'm like, is it already that time? I'm like, it's a bit early. And they're like, hey, it's pumpkin spice season. I'm like, oh my gosh. It's a little early, but yes, it's happening. It's happening, chat. And to be fair, it's after Labor Day, so I guess. Midnight in Exile saying, for $5, I worked at Showbiz for 25 years, warned that DEI would get someone killed for 10. They will do anything to avoid admitting Hannah Gutierrez-Reed was the DEI hire that did it. Yeah, was she a DEI hire or a Nepo baby or a combo? I'm sure it was kind of like all the above. Pirate Tomsky is a new member. Thank you, man. I appreciate it. Or if you're a pirate, should be yar, yar. We thanks you for joining this band of merry thieves. Oh, you're saying in your background. Okay, because I was about to say, I'm like, I don't hear any. Like, I was listening and I don't hear anything. So, yeah, David's like, maybe not in criminal. No, I agree. Interpleader is a very good civil remedy to do stuff. Dolly says, what would happen if you troll in big cases with filings doing self promotions and you're in another state, like Sarah Boone? Oh, you mean like if I filed motions in Sarah Boone? Oh, I could get reprimanded, and what that court could do is contact, here, like that court would contact the Supreme Court of Ohio and disciplinary counsel, be like, this guy's fucking with my case, and they could discipline me. I'm bound by the rules of professional conduct if I'm out and about. So, like, think about it. If I pro hoc vitaed into Florida for a case, or if I pro hoc vitaed into Utah or West Virginia or Maine or, California, If I prolog vitae into anywhere and I go out there and I conduct violations of the rules of professional conduct, could I get sanctioned where I'm out there? Yeah, they could discipline me, but they really don't hold the power over me. What happens is Ohio has power over me. So they would tell Ohio, here's what he did, and they would discipline me for it. So yeah, you are not immune from that. You can't play those games. Those are that there is no like he it didn't happen here, so you can't punish me. It's like, no, they will. Don't try them. Don't try them. Unlimited advisement means the judge is studying the legality of an issue. Sure, the legality or the factual basis, like I got to start figuring out what happens. So taking under advisement means I'll get back to you guys on it. David says I'm researching it now. Yes. I'm glad you're taking a look at it. I thought Ohio was just a meme. Well, you best believe it's more than a meme. So, all right. Oh, Dolly's saying, not saying I will at all. Oh, well, you could get in trouble for different things. I thought you meant like me. Or are you trying to say like, you'd be promoting like, listen, guys, Dolly talks and hearsay for days here on YouTube. And he would just slap that in the middle of a motion as your thing. Like, no, do not do that. Do not do that. No, that was Lainey. She growls. Something got her fired up and she does that thing. That's how she barks. Yeah. That's how she does it. That sounded evil. Yeah, Lainey sounds very dangerous when she barks. All right, guys. So that's it for the Hannah Reid, Kari Morrissey saga. Next thing we got is Sarah Boone. Yes, America's sweetheart. She's had a pretrial a couple days ago with her new attorney. And it sounds like they're working together. Things are going well. The motion for new trial continuance was denied, which I still think is nonsense. She's got an attorney. They're trying to work on things here. I don't think it's fair. Let me see here. Oh my gosh, you guys are going. Sorry, I'm checking something out here. Okay, that didn't work. So here we go. Here we go, Sarah Boone's. You act like this judge cares about fairness. Well, yes, that's true. That's true. That's true. Yes, he's just all about like we're trying to get this done, which I think is a horrible thing for him to say. All he's gonna do. Chat Center Frat says my old blind dog would just bark in the backyard to feel like a dog. Oh, I'm sure. But yeah, here we go. So here's the Sarah Boone's pretrial, her most recent one. We're gonna take a look at it. We'll listen along and see what happened here. Like I said, guys, this is just some basic stuff. We're gonna take a look at it. So here we go. Oh, why did this? Forgot where it was like. So there's Judge Kranick. No, I don't know why it's.
Oh. Sir, hang on 1 second. I'm waiting for the state. Thank you for your patience. Thanks.
Hold on here. We're going to skip ahead. Let's get. We're waiting for the prosecutors. That happens sometimes. So here we go. There's Sarah. Very happy. She's in really good spirits. Comparatively speaking, compared to other times.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed.
There we go. I don't know why I did that, chat.
On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense that was filed on the 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that the JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for that spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I approach them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the hearing.
Thank you. The only thing I saw in the court file, counsel, when I was prepping last night was the motion for statement of particulars, the comments count 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have a motion for statement of particulars filed 8:10 yesterday, but I do not have the motion for additional discovery filed 8:34.
I don't know why the court was not able to post that, because they were filed one right after the other.
One's in the court file, the other 3 aren't.
No,
They were all filed yesterday, 19.
certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator, and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing of their response filed on August 15th. They're not here. Your motions for these various experts report they were sent to all persons on service lists through the e-portal. But I don't know how I can address these this morning without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I filed my notice of appearance on Friday,
Yes, sir.
and I've spoken with Dr. Berklin 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Berklin. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and provided to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and he can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to?
Oh, real quick. I know you guys were, some people had asked me a question earlier. They'd asked me yesterday about why is this guy using the reconstructionist and people up in his area? There's nothing wrong with that because it's people he knows and experts he knows he can use and he trusts, and he thinks they're reliable for what he needs. So there's nothing wrong with him saying, I want to use the expert up where I'm from. What was that? He's allowed to do that. That's not actually a problem here.
Get that information to him.
If he wants to come back to my office, we can do it this morning / this afternoon.
You sure?
Office in the building?
Yes, it's in the courthouse.
Right there. Come out front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., State will give you the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally and in writing, given the lack of time we've had to prepare to make a formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery?
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and the motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense, court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing the defense. And there's a second doctor, Dr. Michael Brandon. I don't spell that out for me, sir. Dr. Michael Brandon. I don't know.
B-R-A-N-N-E-N?
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brandon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not.
And
I've tried to reach out to Mr. Brandon this weekend unsuccessfully, and my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. I will be, that's the only other witness I'm going to need an appointment for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burkle. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Torres.
Don't chew gum in court, guys. Please don't do this.
Involving the apartment complex, which is in Winter Park, that was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these 2, as well as we're trying to get together the 911 calls that Sarah made.
We'll get to these guys.
Made about the disturbances between that couple. So he,
The guy with the gum was the private investigator, Billy Lane. He did all the scanning, all the stuff initially. He's the private investigator working with Sarah this entire time.
he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved and their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other, of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs, since they've already said yes, but file it, and we'll try to tee it up for hearing as well to see if they have any position, or it could just be the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance file that was filed on August 30th. Court's had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Roberts.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it. It is critical to my theory, our theory of defense, battered spouse syndrome. As you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I believe you were involved at that time. I may have been.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles, sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take a deposition. I think they may have a right to hire their own forensic expert to go out and interview to see if they agree.
And remember, guys, I brought this up before. All this takes time. This takes a lot of time. Even if you want to do it quickly, you're going to need like 90 days. That would be the quick turnaround. But look at the judge. He doesn't seem to give a shit.
But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Padilla has done a lot of work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. Based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without battered spouse attempts, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several of Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would oppose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on battered spouse.
Any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on battered spouse on Monday. We can't wait a week that the time has expired. If the judge doesn't continue it today, he wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or
Now, it's interesting the state says, well, we kind of already have done this. So it doesn't, like, we've been prepared. We already knew this was going to get brought up. Now, the state's in a different position. This is a bit different. They already have their expert. They've already kind of prepared for this. So they're not in as bad a spot as they would be. And I think that's a fair point by the state. It's nice they could see that, like, we're not actually behind the 8 ball here, but, you know, they don't really care if they think this is kind of garbage. And I get that because they had their expert. But this is a problem here. This is an issue. And his attorneys bring up the point, like, if you make me wait, I can't defend her.
wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said that 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, we're going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist.
Now that's interesting. Now he's saying, look, Judge, yes, I can file within 30 days. And this must be his understanding of the law. There might be case law that supports this, that if you're going to file that notice with the court that we're going to bring this defense, you have to have foundation to bring that motion. Otherwise, you're filing privileged motions with the court, motions that are unsupported, and he has an ethical duty not to do that. Now, I don't know if that's true or not. But I don't think this guy's making it up. I'll give him the benefit of the doubt here. He's trying to tell the judge like how he has to do this.
I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can follow that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brandon needs more time.
All right, thank you. State anything else?
No,
All right, thank you very much. All right, Mr. Oaks, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation, you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the 4 Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barlow v. State 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those. In Ramos versus State, 75 Southern 3rd, 1277, and pinpoint 1281, by the Florida 4th DCA in 2011, citing to Lawson v. State, 84 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation and trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwitz, Thompson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida from 2009 to 2012. You've tried.
Now, this is the funny part. He's saying, look, you've got no time, but I know you're a really good attorney, so I know you'll figure it out. This is just absolute garbage by Judge Kranick. What an absolute fucking coward not to give this man the time he needs.
For 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the matter of spousal syndrome of defense, you still have time to file the appropriate notice in accordance with the rule. And considering all the factors as set forth in terms of the state 311, 7, 3rd, 185, and 10.189, 42nd BCA 2020, your motion for continuance is denied. Matter of this trial is still set for October 7th. We will have pretrial the 6th to 27th. Pretrial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County for Circuit Judge Scott Duncan. I've got 12 clients. I've got other people covered, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form order, I'll sign it and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to introduce at trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lang on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted, I don't know if they're originals, but I'm gonna need to look at that. And I went to the jail yesterday, I had to let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what I assume is being redacted. I know some of the audio in terms of clients, comments my client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State.
I'm not certain, is he asking for a continuance again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand it,
He needs to prepare the goddamn case. The guy needs extra time. Come on now. Yes, Sarah's finding out. This is what it's the finding out part. Yes. What attorney is it? This is attorney number 9. But there's also attorney number 10 who's jumped on as well. So.
I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
Give me a moment. On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lane was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations by and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall file with the court a notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail according to the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m. a hearing will be held, courtroom 12A, regarding defendant's review of USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024, pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay. State?
No.
Okay. How much time would you like, sir?
I love this. Like, I'm not extending the trial, but I'm basically going to bend you over the barrel anyway. How much time do you need, good sir? It's like, come on, man. This is a farce. This is a farce at this point.
In order to review the state's digital evidence that it seeks to admit into evidence and tender any objections.
I've got to go by jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial, whatever that is, a week prior to that Monday, October the 7th, the week prior.
State.
I'm going to be amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Jones?
Wait, hold on. Wait, what are we doing on the 26th?
Objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Jones?
Well, that's interesting.
Give me 1 minute.
Sure.
That's it.
State, anything else?
Not this time, Your Honor.
Madam Clerk is going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties have no business before the court. You'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
Now, I think this is bullshit what they did there. Like, you know, at some point, like, this is just Judge Cranick fucking with her. I get Sarah may have fucked with him, but that's not how this works. So that is the end of that hearing. Her attorney did give a kind of brief press interview. And if you guys only want to see that real quick, we could talk about that for him real quick. So here's the interview he gave. He gave a statement after court.
Why this case?
Sarah Boone needed a lawyer. I mean, I can't imagine our system. The case is an aberration.
The new lawyer for Sarah Boone speaking to us for the first time after a hearing this morning at the Orange County Courthouse. James Owen says he will now represent her in trial next month, despite her going through nearly a dozen public defenders over the last few years. Boone is accused of leaving her boyfriend, George Torres, to die in a suitcase back in 2020.
Sarah's been sitting in jail for a while. She's looking for her day in court, and we all want justice to be served. You know, I'm a criminal defense lawyer. I've been doing it a long time. The state has the burden of proof. They have to prove their case. I know there's some strong evidence in the case.
Last week, Owens filed a motion asking for a delay, saying he plans to use battered spouse syndrome as a defense and needs more time to prepare. But the judge denied his request for delay. He also asked to bring in a crime scene reconstruction specialist for Boone's trial.
That expert was not meeting with what Ms. Boone had desired or requested.
So anyways, guys, that is his attorney. You know, he spoke a little bit about this, and I can't find it here, but he did make a statement in this interview of, like, I didn't initially want to get involved. He's like, I laid low for like a month hoping some local attorney would pick up the banner, but nobody did. So he's like, if not me, who? So it's very interesting. It's very interesting. Now that has an attorney, they should move the trial 1 week closer. That would be funny. Well, actually, now we're accelerating the clock, sir. It's in his Court TV interview. Oh, okay. I'll see if I can find that real quick here. We're going to back out. Oh, he has a... Does he have a full... Oh, he gave a full interview? Oh no, because I think the interview I saw, he was like in person and talked about it. Anyway, we're not gonna do that. That's Court TV stuff. But he did file. Yes, you have 30 days to show you I'm serious. You now have 20 days. Yes, but Your Honor, I'm not ready. He's like, you have now 10. And then yes, we do have the filing. He did file today. And this is the beauty of electronic filing. It's all done. So what has he got? He's got a notice of intent to rely on the defense of battered spouse syndrome. Battered spouse, battered louse, tattered grouse. I'm not sure. It's all the same thing. So under Rule 3.201, battered spouse syndrome is going to be used and gives notice of the intent to rely on the defense. And they state that she was suffering from battered spouse syndrome as a result of the physical and psychological abuse at the hands of the alleged victim, George Torres. Apparently his name is George, not Jorge. Dr. Julie Harper will be a Category A witness for the defense in establishing this condition. And here's her information, and they're providing it to the state. Now, like I said, I think the state has already had access to the depositions that Attorney Cashman filed, and that did already. So I don't think there's a problem here for her in that regard. The more and more I think about it, the state is bringing a point like, we've already known about this. We've kind of prepared on and off as each attorney's dealt with this. So we'll see what happens. We'll see what happens there. I don't know if this is going to, I don't know how far these people got, because remember, every time Sarah would fight with somebody, they got fired and it was over and blah, 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 blah. Like, I don't know how far people are prepared. He might be in a better spot than he thinks. We don't know. We don't know. So, Hella, would I be able to be a breakdown of battered spouse syndrome? I can. So, battered spouse syndrome, and like initially it was battered women syndrome. It's a psychological issue that it's been used before when women have engaged. Well, traditionally it was like the woman killed her husband, and instead of murder, we got to manslaughter. At times it was more of a negation when it initially came out. And it's basically intimate partner violence, and it's like a chronic intimate partner violence. And it's also kind of like PTSD rolled in there. It's a combination of things. But basically, it's the idea that, they did this to defend themselves. They killed them. And the reason why they call it battered spouse now is because men can use it technically. And whether or not it's actually going to work anymore, I don't know. Now, there is some people have said like calling it battered spouse is not, or battered women syndrome. Like when you're saying they're battered, like that's not nice. It's not fair for victims, which is like, okay, fuck all that. But yes, that it's the idea that, it's a lot of it's what you're ongoing, and it's how you describe the dynamics where these ongoing abusive relationships go, where people eventually do lash out, and what they do at that point, how they react. And it just like, there's, it affects, they're fearful for multiple weeks on end. They're hyper vigilant, and eventually they kill the person. And then they do what they have to do. And, part of it eventually turns into, you're fighting to protect someone else. And yes, it basically becomes a self-defense argument. Like, why did you kill this person? And a lot of times it became imperfect self-defense. It's been used to argue insanity. There's a lot of things you can do there, but a lot of times it's been used as a mitigation. And I hope that kind of explains it there. How about battered chicken syndrome? Well, yes. But I hope that explains the... I tried to find a study to show on my stream if you could tell us more. Does that make sense though, Hella, as far as like what you're like, does that make sense kind of what you're looking at for at this point with that? Because I mean, that's really it. It's like the women, the person will react. Does the person have to be in fear of their life at that moment? I think that it really all depends. It's not necessarily something with battered spouse. I don't know off the top of my head, but that they're reacting like, I know how this is going to go. I know how he gets when he drinks and he's starting to get mad and angry is usually how things go from there. But there usually is there usually is like an idea something's going to happen. It can't just be like, oh, Bob was watching the football game and I walked up to him and went right in the back of the head. It has to be like Bob was getting angry. I know it's coming. He's going to start beating me. So I grabbed the gun or I grabbed the knife and then I just went, bop. Okay, that's battered woman syndrome. Like I said, he can't just be, oh, Bob woke up and he was mad the Browns lost, so he was going to kick my ass. It's all about mind over batter. Well, sometimes your mind turns into batter if you get it beat hard enough. Yeah, see, you're almost arguing he had it coming in a way, but it's more that you're kind of like preemptively defending yourself, and that becomes the issue there. And then it's the idea like I'm going to get hurt again, and I need to do this. So it's a very much a preventative self-defense. It seems like this defense would need to suppress a lot of evidence for this to work. I mean, I don't know about that, but yeah, Sarah's got a lot of problems. And him trying to suppress that stuff, I don't know how well that'll go with the court. Him trying to suppress things, but here's the thing. He doesn't have time, so is he really going to be even able to do that? I mean, he's got to sit down and prepare that. Now he's got to prepare a suppression motion on top of this, and not just some hammered dog shit one. Like, there's a lot that's going to be a problem for these guys. But yes, it's very much they're building the arc, and it's like halfway through the rainy cycle already. Yes, they both hit each other. Oh, I'm sure these were both codependent, abusive drunks and substance abuse users. I'm sure that's actually what happened, but she has the right to the defense. Why does the cup sound like that? Clink. Yes, it's not almost had it coming. It did have it coming, and it might be valid for some people, but that's what it is. Yeah, that's a fair point. That's a fair point. If it's not crime, it's pre-crime. Well, in that situation, you can do it. The interview she did and the body cam footage are big problems. Oh, yes. Yes, the interview she did, the cell phone picture she took, she's got a lot of problems here, chat. A lot of problems. And I don't know what she's going to be able to do. I don't know how her attorney's going to fix it, but, he's got a plan. I want to see the Publix footage. Jabba does use a coaster. It's a marble top. It's not going to hurt anything. Hell is saying thanks. It'd be cool do one of these together sometime. Like, what? You want to get beat? I don't know what you're meaning here. No, we might. Well, hey, Hearsay for Days, as Hell likes to talk about, is every Sunday at 4 p.m. Eastern time. And I know 2.0 is going to be in there. I might make an appearance. Not sure yet. Clink, clink, smash. Oh, it doesn't hurt any. It's not going to hurt anything by just banging around a little bit. She wants to put you in a suitcase, and she need a big fucking suitcase. Gonna need a team of people to wedge me in there too. So, so to be Flair saying, "What was the fuck with the audio?" Remember, this is set up more of like for pretrial, so they're not too worried about the audio. It's good enough. Good enough. James Reese says, "What did they charge Sarah with? Second-degree murder. So she's facing life in prison, but she's not charged with first-degree murder." Justin saying, "Could she say she feared death while she's in the suitcase?" Yes, I know Andrew Bronca talked about this a little bit back then, but could she argue it was a self-defense argument? And that's what battered spouse really is at the end of the day. It's like I said, it's like a kit bash. You're lobbing a bunch of stuff together, but she could argue it was self-defense, and that, like, let's say she thought a way to protect herself from him was locking him in a closet. Let's use the argument here. She locks him in a closet because he's getting drunk. She's getting scared, and he's in there. But let's say this closet has airtight. Let's say it's an airtight closet, and she locks him in there, and it's like, And he's in there screaming, help me, I can't breathe, help. You know, and she's like, well, if I let him out, he's going to fucking kill me or hurt me. I don't want to do that. You know, but like she didn't realize she was going to kill him, but she preemptively was like trying to restrain him and corral him, and that accidentally killed him. I mean, this could easily turn that. I could see the jury buying that and saying, okay, well, it's manslaughter then. I can easily see that. Red one for £1.99 says, £1.99 sterling of the king sterling. Says, yo, George R.R. Martin, stop streaming, finish the book. No, you finish the book. Also, thank you for being here, Red One. I appreciate it. You could do a better Jorge impression than that, Sean. Come on now. No, I can't. Sarah, help me. I can't breathe. Help. That's just a scary way to go, man. That is nightmare fuel. So, like I said, we will see what happens. We will see what happens. I like how Runkle calls outsmarting your jailers a mental illness defense. Yes. Hold on here. Apple says Sean is against funding the war in Ukraine. Is Sean against sending $18 billion a year to a certain other country that is also currently at war? Yes. Yes. I'm against sending out that aid like that. They can handle their own business. If they want to buy it, they can buy it. They have money. Oh, we know they've got money. They've got all kinds. They have a world worth of money. They really want. But yes. No, he has a gross Long Islandish accent. Who, me? Who has a gross Long Islandish accent? I don't know who we're talking about here. Apples, yes, our greatest ally. Yeah, no, they're not. No, they're not. It's very interesting how they treat us. Very interesting how they treat us. On the plus side, I don't have to worry about being yeeted by a suitcase. True. Yes. All right, guys, I think that's it. We're like Sarah's wrapped up for the week. I mean, she's getting screwed, but we'll see how long she can survive. And we'll see. I mean, her attorney's ready to rock and roll, but I don't know how it's gonna go. I don't know how this is gonna go. Like I said, I'd love for it to be better, but yeah. It's yeah. That's what it is. It's what it is. So we'll see. We'll see. Like I said, I am not proud of hearing how this judge is treating it. So we will see. We will see coming up. If you guys have any more questions. Sarah's gonna use that Chase Bank hack to pay her attorneys. Ah! Oh. That is funny. Oh, Jorge, he's like, Sawa. Well, I'm sure he was like dying. I don't think that had anything to do with him being from Long Island. I'm sure that was him dying more than anything. In the phone audio, when he cries out, I can't breathe, Sarah replies like when you choke me. Yes. Can I look at the second attorney that signed on? Can you look at his misconduct for handing client funds? I mean, I don't know what, I mean, if there is, there is. If he did it, he did it. If he got accused of it and sanctioned, then, I mean, it happened. I don't know what more to say. I guess it's a good thing there's no money involved. I don't know. Are we going to do locals tonight? No. There's no reason to do locals tonight. And JS says, I wonder what this backstory was on those jackasses in Bakersfield. Oh, that's sitting the crazy motion on their own. Like I said, I think those are just crazy people. I think those are just crazy people. Like, I don't think there was a point there. I don't think there was a point to it. I really don't. J-Rock says, is there a goal, Sean, for more? No, but we'll probably have a goal tomorrow. Tomorrow night we'll have a goal. And Scott White said, where's F1 this week? There is no Formula 1 this week. They are on their way to Azerbaijan. So next week will be the Grand Prix in Baku, but this week there is nothing. Sorry. Yes, true. Yes. He's asphyxiating, and I'm like, ew, you talk gross, like totes. Like, oh my gosh. I can see how that's unfair. Well, at least you're being honest. Jim Cox says, when are we going air compressor shopping? I already did that, and I got to go pick it up. So I got to go to Lowe's tomorrow. Are we doing unsexy modeling tomorrow? Yeah, we're going to actually start trying to use the modeling channel tomorrow. We'll give it a shot. We'll do a debut. Or I'll do it like as a dual stream or something. But that will be the plan. Yes, and I like this new attorney. I like this new attorney as well, Lynn. I really do. I think he's going to do good work for her. This guy's very serious. I'm happy that she's got good counsel. What do I think of the 14-year-old who shot up the school in Georgia being charged? It's very early to see what's happening there, and I don't like it at this point, because how do we know if this is the proper thing? It doesn't seem like it's the proper thing at this point. And I only bring that up because the idea is like, oh, he bought the gun and it's just like Ethan Crumley. And it's like, but it's not. He bought that gun like 9 months ago. And now it's being used. And also, like, we hear, oh, the cops in the schools knew. And they're, yes, once again, we're arresting everybody but them. It's neat how they always get to go, oh, well, we couldn't do nothing. It's like the school couldn't do shit. Absolute bullshit. And in a place like Georgia, I guarantee you if this works, you're going to see them going after gang members, and you're going to see some moms in the hood getting hauled in a police car because of what Junior was doing. We don't want that. This is what it's going to lead to. So no, I don't like this. I don't think it's a good idea at the end of the day. But who the fuck buys a kid under federal investigation a gun? Well, I mean, the cops showed up and like, they're like, yeah, we think he's sus. Are we going to do anything about it? Well, no. Then what's the problem? Like, he was under investigation. Like, oh, yeah, he's making threats. Are you going to arrest him? Is there a crime being committed? No. Well, no. Then what? What should they have done? What should they have done at that point? If the police and the school and the government are not going to do anything, is it their job? Is it their job? You know, I'm sure Dad said, hey, policeman, what's going on? The cop's like, don't worry about it. What do you want him to do? What do you want him to do at that point? Told the dad not buy the kid a gun. Well, okay, but what else are we going to do? When he shows up at school, starts stabbing people. But they told the dad not to buy the kid a gun. Okay, but like, if he buys it, is it breaking the law? Are you going to stop him or do anything about it? Are you going to flag him in NICS to say, we told you not to buy the gun, don't buy the gun? No, they didn't do anything about that. That's the problem here. Nobody else fucking did anything, and we're going to punish the parents? Yeah, because everybody else gets to hide behind the government. That's bullshit. I think that's the big problem here. So, yeah, cops cleared him of wrongdoing. Well, then that's it. Case closed. Near met at people because they did what? Like, I don't think that's fair. Like, okay, well, you're done. Sorry, there's no evidence here. Well, then what do you want him to do? Fuck do you want him to do at this point? Like, that's not... I'm just saying, chat. That's how I look at this shit. I just don't think it's fair at that point. I just don't think it's fair. How do you deal with this? So, also, real quick chats. I know you guys were asking, are the channel for modeling. I did change this so you guys know. But dad is not responsible for giving a kid who said he would shoot up a school and then he shot up a school. Yeah, he said it like a year ago. Okay, well, I mean, at some point, like, what are they going to do? So, I mean, like, that's part of my issue here. Cool, let's start arresting everybody, because as long as everyone else gets arrested, Bella, I'm cool with that. As long as some cops, some feds, and some teachers get arrested, cool, let's get them all arrested. You know, I want to see other people get arrested. So, they're not arresting the cops, they're not arresting the teachers, they're only arresting dad. So, that's my issue here. Little Miss says the grays are bad, go to subs only. Oh, I have no problem. I love the grays. Grays are helpful. They make you appreciate how good it is to be green. Yeah, the Crumbly administrators were worse than the school parents, or the parents. Anyways, guys, this is the channel. Oh, wait, hold on here. Why is it showing up like that? Anyways, it's Sean's model bench. That's going to be the channel. And we are going to probably be on there tomorrow night, taking a look at stuff, having some fun. And yeah. No logo, not yet. I'm working on that. I'll put a link up, and we'll probably do like a dual casting thing. I demand a sub, I paid. I demand subs, I paid. I don't... Homeschool Clyde, you won't get arrested, yeah. Post a link in chat. I'm trying to work on that. Give me a second here. Give me a second here. Why is this not working? All right, here we go. Customize channel. What is the link? All right, hold on, chat. Here we go. Let me see if this works, just to make sure this is right. Yep, there we go. Well, let me hold on here. Oh, that's why it's not working, because I switched accounts. Oh, a couple people subbed. Thanks, guys. Thank you. Anyways, here is... Yes, the greens keep the lights on and the trains on time. No man says I've described like a good boy. Well, thank you. Yeah, guys, and here's the channel, the new channel. So I struggle with technology. Yes, I do. Thank you. I miss Kino Casino. Need to come back for their break. Yeah, they will at some point, guys. Don't worry. There'll be enough A-logging for them for days. There'll be A-logging for days, chat. Current subscribers 77. Holy cow, you guys. Wow. 85? Jeez. You guys are just going crazy. Thank you. Almost 90. Wow. Maybe so I can live stream on there on its own. I'm the reason you have the Ryder truck. Well, Timothy McVeigh is responsible, but I asked for the lolicon or the emoticon. Yeah. Bab says, "What does A-logging mean?" A-logging means just really aggressive trolling, where you like really up someone's ass and you're harassed. Like, it's not harassment; it can be harassment, but real A-logging is like what Kino Casino does, where they're just really breaking your balls, or like when I've read Nick's motion, I consider that'd be fair to call that A-logging. I consider it A-logging. So, yeah, just being real tough on somebody. Chill when I have over 1,000 watching. Yeah, that would be fun. Yeah, but then I got to get the watch time in, but I'll work on that. This Laura Shyster A-logs. Yes. Yes, A-logging comes with Anthony Legato. It does. But A-logging is a thing. So, you guys, there is no goal tonight, so don't worry about the goal. Yes, A-logging is assessed as a negative connotation. I agree. I don't disagree. Yes, A-logging is worse than the person you're making fun of. Yeah, but you can A-log people you can be productive way. It can be productive at times. So, all right, chat. Well, that is it for tonight. We are going to wrap this up. We'll be back tomorrow. We might do a show in the afternoon. I don't know, but we'll definitely be doing an evening show. But definitely, we love your blog. Thank you. So, guys, we're going to leave this alone for tonight. And just remember, until next time, just because you did it does not mean you're guilty, especially if you're Alec Baldwin. And maybe if you're Sarah Boone. We don't know yet. We'll find out. We'll find out in a month, chat. Sadly, we're going to find out in a month.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy?